And the lordship, lordship with the consent of the other side, I beg to mention item number 8, lordship. Lordship, in this case, we are required some time, lordship, to file our affidavit, lordship.
Here for whom?
Respondent, lordship, all the respects.
For the CGC, central government.
Yes, Mr. On behalf of SS lordship.
Okay. And from the other side. Okay. On a request made on behalf of the Union of India, matter is adjourned to be listed on when? 3rd of August? 3rd of August to enable filing of affidavit in opposition. Is there any interim order? 3/8. Okay. Yes.
May I please your lordship? Lordship, I beg to mention for listing on WPC, lordship.
Or
For admission, lordship.
matter of which year?
2025, lordship.
25. What is the urgency?
Lordship, there is a stay order against eviction, lordship. So,
You file an application.
lordship,
File an IA, we'll consider your IA.
lordship, we are for the respondent, lordship.
Understood. You file an IA for vacating the interim order. Okay, we'll have it after the vacation. When we can have it on 17th. Ideally, you have to file an IA. Yes.
It is a launch. I beg to mention item number 8 with the consent of the other side.
8 has been mentioned just now.
Much of my lord, there was a previous interim order.
That was what we have asked. Madam has said no, nothing.
I'm
You're-
a petitioner in this.
Understood. Whoever mentions, he or she should know whether there's an interim order. Where is the lady? Why is this happening? The interim order passed earlier to continue till the 3rd of August we have fixed.
Much obliged.
May I please your lordship, with the consent of the petitioner, I beg to mention item number 7.
Yes.
Your lordship, in this case, we will be filing an affidavit. Going to clarify the terms of petition.
You want to file an affidavit on behalf of the APDCL.
Yes,
How much time do you require?
after application.
Inform the other side.
Yes, yes, petitioner.
There are private respondents also.
Yes, private, I will inform the private.
Okay. Madam Hazarika? You're for the private respondent. Okay. How much time do you require?
After application, your lordship.
After vacation, how much time? When do you give it? Okay. On a request made on behalf of the APDCL, matter is adjourned to be listed on, we'll have it on 27th of July to enable filing of affidavit in opposition. No interim order? Okay.
May it please your lordship. Lordship, in this case, the petitioner has submitted material component under MGNREGA and duly submitted the bills before the district program coordinator, that is the district commissioner of Bazalai district, lordship. Thereafter, a letter was issued by the respondent number 2 stating that the works undergone under the Bazalai district, some of the works are not permissible under the MGNREGA scheme, lordship. Thereafter, directed the deputy commissioner to district commissioner to conduct an inquiry
Correct.
and submit a report, lordship. Thereafter, the district commissioner DPC conducted an inquiry and submitted a report before the respondent number 2 stating that the works that the petitioner has conducted comes under the purview of the MGNREGA and thereby requested to approve the bills submitted by the petitioner, lordship. But till that has not been
Mr.
done,
Doctor,
lordship.
My lord, I have preliminary objection on 2 grounds, my lord. This is fully covered under terms and alia, my lord, because, my lord, the bills, my lord, the year was, my lord, 2019-20 and 2021. So 3 years has already been gone. Some delay, let's say the quarter.
no, he is not per se with the grievance of non-payment of bills. He is on the aspect of whether those were within the permissible limits of MGNREGA. That is one aspect. But ultimately, you will be correct. Ultimately, the question would come whether the bills can be cleared.
Yes. But
And he has not raised it within 3 years.
Yes. That delay is there, my lord, and petitioner himself is saying, my lord, that commissioner, who is the highest authority, my lord, in this case, my lord, they are denying. The factual disputes are there, my lord.
Lordship, kindly peruse Annexure I,
Okay.
lordship, page 30, lordship.
RPP Borderland Learned Counsel for the petitioner who claims to have supplied certain articles under a scheme in a scheme under the MG and Rega.
Lordship.
Full stop. However, there were certain objections with regard to the items which were supplied. Full stop. The
With regard to the works, Lordship.
with regard to not supply, with regard to the works done, I got to supply na works done before. The grievance of the petitioner is non-release of the bills in spite of non-release of bills. Full stop. It is also contended that the district authorities have recommended such payment even whereafter the bills have not been cleared. Full stop. Para. 3. As Dr. the Learned Standing Council PNRD department has, however, submitted that there are disputed questions of fact and the petitioner has not met the requirements laid down by the Honorable Full Bench in the case of Tamser Ali versus so-and-so reported in so-and-so. Para. That notice be issued, returnable on 31st of July 2026. 3. Dr. the Learned Standing Council PNRD except for 1, 2,
4, and 6.
1, 2, 4, and 6. District Commissioner, Madam, you does 3 and 5. 3 and 5?
3 and 5
3 and 5 extra copies. Full stop. The question of maintainability of the petition is, however, kept open.
Second item also same.
Same.
You are the council?
Yes, same.
Okay, same.
Response numbers are also same.
Okay.
Oblige, your Lordship.
Nothing more.
May I please, my lord? This is a petition against the adjudicating authority, my lord. The primary challenge is, my lord, the quorum non-judice. The member who is sitting, my lord, before the adjudicating authority, PMLA.
Why is it before this court?
Sorry, my lord.
No. Why is it before this court?
Because, my lord,
it's a
the
bench 5 matter,
bench
isn't it?
is against the PMLA adjudicating authority, my lord.
Bench 5, isn't it, madam?
It's a writ petition, my lord.
No. There are you are not conversant with the practice here. Writ petitions have been divided. There is bench 5 matter. Madam, what do you say? Is PMLA are supposed to be bench 5 matters?
It's a PMLA. My lord, it is not the PMLA prosecution complaint.
Yes.
It is with regard to the adjudicating authority.
Understood.
Yes.
These are matters which comes under the residuary jurisdiction, bench 5. No, we don't mind taking up the matter at all, but there is a.
But I don't think so. My learned friend will have a
No,
problem.
she will
with
not
it.
have a problem. No one will have a problem. System will have a problem. There is a.
Rather, it's a
system.
very interesting issue, my lord. The member who is sitting before the adjudicating authority is a financial member, my lord. He is not a judicial member. So the adjudicating authority is quorum non-judice, my lord. The
Where is the
proceedings,
requirement?
my lord, the requirement I show. My lord, may just have the section PMLA Act for a minute.
Section 6.
Yes, my lord.
Please read.
My lord, may just have 6.2 and 6.3. My lord, there are 148 orders of different high court where the proceedings are stayed.
Just a minute. Just a minute. Oh? That's what can you PMLA? No,
It's a civil aspect of the PMLA, my lord.
No, we are not relegating to any criminal court. There are 5 civil.
I understand.
Civil courts, file
But my lord-
courts which takes up writ petition, which are in civil in nature,
Yes, yes.
not writ petition criminal even.
My lord, we both will not have any objection. My lord, we leave it to the court, my lord.
No, the predicament which you would suffer is today is the last date. If we ask you to go to bench 5, you may have some difficulties.
Okay.
That is, otherwise we'd have sent you to the appropriate court.
Then, my lord, we'll request, my lord should take it, my lord. It's a short issue.
Yes,
Lord-
madam, what do you say?
Whatever.
No, whatever. He is taking up a law point. Section 6 is relying upon Section 6 stipulates who would be the members.
Lord, I have given a compilation of judgments.
Now
140 courts have, Lord, 140 judgments of different high courts have stayed the proceedings because this issue is now pending in Supreme Court. All proceedings before the adjudicating authorities are stayed, my Lord. I have given a compilation of the judgment. My Lord, may just have the bulk compilation which I have given, my Lord, are the orders of various high court across the country, my Lord. 148 orders, my Lord, where all proceedings are stayed based on quorum.
Let us see.
Yes, my Lord. I'll satisfy
Let
the
us
court.
see.
My Lord, may just have 6-2 for a minute. My prayer, my Lord. Show cause notice to be stayed, my Lord.
Chairperson and 2 members. Provided that one member shall each shall be a person convicted of law.
My Lord, can I read 6-2?
Yes, please.
2 sections. The central government shall by notification appoint
Oh, we are reading of what?
6-2 of the PMLA, my Lord.
Yes. 6-2.
6-2. The adjudicating authority shall consist of a chairperson and 2 other members,
Correct.
provided that one member shall be a person having experience in field of law, administration, and finance or accountancy. Now, my Lord, may have 6-5.
Hmm.
B.
Hmm.
A bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members as the chairperson of the adjudicating authority may deem fit. Now, my Lord, may just turn to one more, Rule 3.
Rule.
Rule 3, my Lord, it is annexed with my petition at page 137.
Just a minute.
These rules are notified, my Lord. There are 2 rules I want to read, my Lord. Page 137.
Just a minute, please.
It's an official gazette, my Lord.
No, we are having the direct. Rule 3.
Yes, my Lord.
Maintenance.
No, my Lord. It says qualification of appointment of a member.
Okay.
At page 137. It starts, is annexure?
Just a minute, please.
Annexure 6.
Name of the rules, please.
My Lord, it's called, the rule is called, my Lord, it's an annexure,
Page 136.
page 136, my Lord.
Hmm.
Prevention of money laundering, appointment and condition of service of chairperson and member adjudicating authority, rule 2007. At page 136,
136.
the rule starts.
It's not there in this 136.
So we extended with the repetition.
My Lord, it's in the writ petition, my Lord.
No, we have
Yes.
we are trying to have a look at the rules. It's not there in the 136.
Yes, my Lord.
Yes.
My Lord, this is the gazette. My Lord, may come to page number 137. Rule
Rules of
3.
2007.
Yes, my Lord.
Hmm.
PMLA appointing rules.
Which rule?
Rule 3, my Lord, at page 137.
Yes.
An adjudicating authority shall have 3 members,
Hmm.
1 from field of law
Hmm.
and 2 from field of administration and finance. For a member from field of law, a person shall be qualified to be appointed as qualified appointment of a district judge.
Hmm.
So, my Lord, that is very clear.
Hmm.
Then, my Lord, may just have one more rule. The rule starts at page number 140 and next P7. How the order sheets will be signed. 140.
140.
Yes, my Lord. Annexure P7.
Yes.
The rule is called section 1, my Lord, may see. Adjudicating authority procedure rule regulation 2013.
Is the regulations of 2013?
Yes, my Lord. My Lord, may have rule 26 at page 147. Rule 26, 147.
Hmm.
2. Every sheet of the order shall bear signature of the chairperson and member constituting the bench. So there has to be minimum 2. Now, my Lord, may see the show cause notice for a minute in this matter. The show cause notice at page 120. He himself calls an acting member.
Page
120, my Lord.
120.
My Lord, relevant is at page 122. He is appointed as a financial member.
Just a minute, please. $120.
Yes, 120 is
This
the
is show cause notice.
show cause. Relevant is at 122.
What is there?
But he's appointed as a financial member. He starts calling himself as a acting chairperson. So this show cause notice, my lord, is defective because it cannot be done without that, my lord. Now, my lord, may just
No,
see.
in absence of a regular chairperson, how do the
Yeah, that is
function? No, no, how does it function?
my lord, he is the sole person who is functioning, passing orders, my lord. So across the country, all orders are stayed. That is the compilation. There
Now,
is one
after
judgment which is
After
attained.
this, this was issued when?
My lord, this is issued.
This was issued on 8/5/2026.
Yes, my
Have
lord.
you filed your, show cause?
No, my lord, I cannot, my lord. It's a quorum, my lord. The show cause
No,
time.
no, have you done it as a matter of fact? Not done.
No, 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 because the date is 28th of June to do it. The hearing now is, my lord, may I have page 121? There's a time period given. We have set a timeline. 28th June, I will have to file a reply.
Where is
5th of
it?
June,
Where is the
my
date?
lord, page 121. It says the defendant is also required to submit reply on email ID so and so by 28th of June. And then rejoinder 5th of July, 5th of August, final hearing 29th of September. 9th of September, sorry. Now, my lord, the judgments, my lord, just for a second to tell, my lord. My lord, may I have given a compilation. Compilation 1, my lord, may see. Volume 1, page 38.
38.
Yes, my lord. This is a judgment, my lord, called Eastern Institute. Exactly same issue arose.
Yes.
My lord, may just see the relevant portion at page 42. Direction was given to the central government to appoint the other members.
Which compilation are you?
Volume 1, my lord.
Volume 1, yes.
Yes,
Page-
my lord. The
page?
judgment is at page, my lord, 38. It is
38
called Eastern.
38 is a continuation of, not 38. 36 starts Kulbir Singh Soni, volume 1. And 38 is a continuation,
Sorry, my lord, volume 2.
second volume.
Volume 2.
38.
Yes, my lord. My lord, may see Eastern Institute for
Correct.
Integrated.
Yes, 38 is
My lord,
institute.
same quorum issue. My lord, may just see the final direction at page 42.
This is Sikkim High Court.
Yes, my lord. It was challenged to Supreme Court. Now the SLP is withdrawn. Right now. Page 42. In this proceedings was stayed and direction was given. My lord, may have 19. Respondent number 1 shall take appropriate step with the concerned authority of central government to appoint judicial member of adjudicating authority urgently within a period of 3 months and not later than that.
This was adjudicated finally.
This was adjudicated, order
And it
passed.
was taken to the Supreme Court.
ET
and
took it to the Supreme Court. The
and
Supreme Court order is here, my lord.
withdrawn.
Withdrawn, which is now at page 49. There were a batch of matters, my lord. We are doing those matters, but they chose to withdraw this
Okay.
SLP.
Yes, we issue notice at this stage.
I am requesting for a stay of the proceeding. That's the, my lord, may just have
What is your name?
volume 2, my
Your
lord.
name?
Jatin Sehgal.
Heard Sri so learned counsel for the petitioner who has put to challenge a proceeding initiated wide show cause notice dated
8th of May.
8. Where do you find the date?
My lord, the date is at bottom, my lord.
Dated 8/5/2026 under the Prevention of Money Laundering Act 2002 within bracket PMLA.
That
Full
is the
stop.
intimation.
The primary ground of
That is the
challenge
intimation to the-
is that the is violation of the requirement of section 6 of the act, which lays down the quorum, full stop, by drawing the attention of this court to the impugned show cause notice, the learned counsel has submitted that the same has been issued by the, who is it?
Member finance.
Member finance in the capacity of chairperson acting which is chairperson, which full stop. He submits that there is a major jurisdictional error in initiating the said proceeding by violation of the requirement of quorum. Full stop. The learned counsel has also submitted that similar matters have been put to challenge, which are stayed, and presently the Honorable Supreme Court is also in session of the issue. Specific attention of this court has been drawn to an order passed by the Honorable Sikkim High Court in the case of Eastern Institute for it to page 38 side of wherein wide judgment dated 22/9/2015, the matter was decided in favor of the petitioner who was aggrieved, who was similarly aggrieved. It is also submitted that though the Enforcement Directorate had filed an SLP, the same was withdrawn. That notice we issued returnable on. Yes, give us a date, Mr. Any date convenient?
Not any day.
You come from outside?
Yes.
Yes, tell us a date. In first week of August?
Yes, no.
5th of August, is it okay? 5th of August?
Here after another judgment is there. This is of 2023. This is of the High Court of Calcutta Logic. Are the info system deleted on another way?
What has been decided?
My lord,
What has
let
been
me
decided?
argued by me, my lord. My lord, may I have given in the compilation.
Okay, that doesn't.
Even RP is in the Supreme Court, my lord.
On 5th of August 2026.
But can it be 4th, my lord?
4th may be difficult, either 5th or 7th. You have it on a Monday, Wednesday, or a Friday.
Then my lord, 5th is fine.
5th. 4th, Tuesdays and Thursdays are hearing days.
Please.
So we may not have. 5th is okay. 5th. Madam Devi, for all the respondents?
One and number, who I think we have made the member of.
No, not by name. Not by name. So you accept on behalf of RKD Chaudhary or yourself? Okay. Ms. L. Devi, learned CGC accepts notice on behalf of the respondents. Let extra copies be served during the course of the day. Para. So the learned counsel prays for an interim order. Para. Considering the facts and circumstances and also the orders passed by various high courts, this court is of the opinion that an interim order is called for. Full stop. Para. Accordingly, it is directed that the impugned show cause notice shall remain suspended. Full stop.
That may be decided on the basis of the
Huh?
interim law should not be there. Of objection until.
Now, if the jurisdiction is challenged,
Lordship may be further there. It is not that question. You can
that is
decide.
why we are asking your views. You have said nothing. After passing of the order, you start to argue. What is this kind of practice?
Notice section. Lordship, between notice section.
Notice and notice will also be consideration of interim order.
No, Lordship may read further, Lordship. May I?
Which one?
Lordship, section 6, Lordship. My friend has read up to that provided that 16 Lordship. An adjudicating authority shall consist of a chairperson and two other members, provided that one.
Use the microphone. Madam, you use the microphone. Yes.
Provided that one member each shall be a person having experience in the field of law, administration, finance, or accountants. Then 3, section 6(3) Lordship, a person shall however not be qualified for appointment as a member of an executive authority in the field of law unless he is qualified, A1 is qualified for appointment as district judge, or 2 has been a member of the Indian Legal Service and has held a post in grade 1 of that service. B, in the field of finance accountancy, or administration unless he possesses each qualification as may be prescribed. It is not that he should only be qualified in law. It can be in any law, finance, accountancy, or administration. If it's clear. And next.
No, the argument is
number.
not that. He's not saying that this particular member
a single-
only because he is not qualified in law. It's on the quorum. What should be the quorum?
It can be settled, it is settled question that even single member benches of adjudicating authority as well as appellate tribunal under PML are legally permissible, Lordship.
From where are you? What is your support?
Lordship, my support is, well, Lordship, I place reliance on RP Infosystem Limited, Lordship. May I read, Lordship?
Which case?
Lordship. RP Infosystem Limited and another.
Where do you get it?
Lordship, it's.
I have you given the list?
My lord, I clarify, yes.
No,
There are-
we'll come to
Yes.
the letter.
May I read the paragraph, Lordship? I provide the copy, but I
You
have.
should provide the copy. You're expecting an interim order to be
Markup,
considered.
RP.
Shortage of time, I couldn't. I'll
No,
read
we
out.
don't have RP.
May I read, Lordship?
Yes. What is the citation? What is the citation?
Lordship, 2023 SCC online, CAL, 2391.
Calcutta, 2391. Please have your seat.
RP
we'll come to you.
Infosystems.
RP?
RP Infosystems Limited and another
Yes.
versus Adjudicating Authority and another.
Okay.
Lordship, I will read the relevant para 29.
29.
29.
Yes.
In J. Shekhar case, two decisions, one of the High Court of Sikkim and the other of the High Court of Gujarat were relied on by the petitioners, which were decisions of single benches of the respective High Courts. The division bench in J. Shekhar case held that they are unable to agree with the decision or by the learned single benches of the Sikkim and Gujarat High Court, as in the said decision, it has not been noticed that under section 25 of the PMLA Act, an appeal is provided for from the order of the adjudicating authority before the appellate tribunal, and such appellate tribunal is not equivalent to the High Court since an appeal against the author of an appellate tribunal is provided after. Thus, it was held that the hierarchy of the judicial government under the PMLA Act presents a very different scheme from what is found in other statutes, particularly the Administrative Tribunal Act. 1985. Further, it was held that no two tribunals are alike. The national company members, the national company law tribunal entity comprises of both judicial members and administrative members. However, the same is not in the case of PMLA Act, as neither the adjudicating authority nor the appellate tribunal exercises the powers that would otherwise be available to the High Court, and such power remains with the High Court in terms of section 42 of the Act, both on questions of law as well as on facts. It was further held that there can be single member benches of the adjudicating authority and the appellate tribunal under the PMLA Act, and such single member benches need not mandatorily have to be an official member and can be an administrative member as well. It appears that as against the decision in J. Shekhar case, no appeal has been preferred at the instance of the aggrieved persons, but it appears that the Enforcement Directorate has preferred an appeal. However, such appeal is on a different ground and not pertaining to the decision with regard to the jurisdiction of the single member bench of the adjudicating authority, which was held in favor of the Enforcement Directorate by the division bench in J. Shekhar case. Thus, by a reading of section 6 of the PMLA without adding or substituting words into the statute, it is clear that the adjudicating authority, which comprises of the single member bench, is entitled to adjudicate the matter, and any other interpretation would tantamount to distorting the language adopted in the statute, which is impermissible. In the light of the above, we hold that the appellant has not made up any case for interference with the order passed by the learned single bench. So accordingly, this appeal fails at decision, and the decision directed by the learned single bench in para 14 of the written order shall be complied with. So here it has been decided a single member.
But what about the statute, madam? If you read section 6, please read section 6.
6(5)(b).
No, 6. What is 6? central government shall by notification appoint an adjudicating authority to exercise jurisdiction powers so and so. Number two, an adjudicating authority shall consist of a chairperson and two other members. So that is the requirement of law, one chairperson and two other members. And now who would be the other members? Provided that one member each shall be a person having experience in the field of law, administration, finance, or accountancy. So there is a qualification so far as the members are concerned, who are to be appointed apart from the chairperson. A person shall, however, not be qualified for appointment as a member. These are the, so far as the members of the adjudicating authority. Now, this is not pertaining to the chairperson. Now, in field of law, there has been some further qualification in the field of finance, A and B. Now, from where do you get the requirement or the provision that you can do away with the requirement of members? If you read the statute says 3 members. At times, we have seen that qualification of member, judicial, yes,
Lordship, 6, 5, Lordship.
5, yes,
5.
yes,
Subject to the provisions of this act, the jurisdiction of the adjudicating authority may be exercised by benches thereof. A bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members.
Hmm.
It is not one, it is 1 or 2
Chairman
members.
is along with.
As the chairman of the adjudicating authority may deem fit.
yes.
And therefore, the bench.
So even here, at least 2 persons, chairman and 1.
Yes.
Even if you go by subsection 5B, a bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members, as the chairperson of the adjudicating authority may deem fit. A bench may be constituted.
The chairman will constitute Lordship.
Will he be a
One
part
or
of, will he be a part of the bench?
That-
Huh? What is the meaning?
He will constitute the bench. That is here. 1, it may be 1, it may, but 1 member can pass Lordship. Can be constituted 1.
And how do you interpret, how do you harmonize the 6.2 and 6.5? Now, while constituting the bench, suppose our Honorable Chief Justice constitutes benches of 1 judges, 2 judges. Now here, 6.5 has to be read with 6.2. Adjudicating authority shall consist of a chairperson and 2 other members. That is the adjudicating authority. Now, who will decide? A bench will decide. The bench will be consisted of whom? Now, we can come to 6, what you have just referred to, subsection 5B.
Subject to the provisions of this 5.
Yes, a bench may be constituted by the chairperson
Son,
of the adjudicating authority with,
1 or
not of,
5
with.
Yes.
members.
The chairperson has to be with. Bench cannot be of 1 member.
Lordship, that I will qualify.
Madam will have this on the returnable that will pass an interim order as on today. We'll leave this open, okay? Last question, কি করেছিল?
Lordship, interim may be considered under.
No, till then we're protecting them. We'll reconsider. কি বলে? তার আগত কবা, হ্যাঁ? তার আগত খিনি কবা, last তার place for interim order, বলে গেছে না? Place for interim. The said prayer has however been strenuously objected to by Ms. Devi, who has relied upon section 6, subsection 5B, and has contended that a bench can be consisted of 1 member also. That is your submission? Okay. The matter would require further deliberation. Para, considering the above and by balancing the equities, it is provided that till the next returnable date, comma, the impugned show cause notice shall remain suspended, full stop. Since this order, this court makes it clear that since this order has been passed at the motion stage, comma, the same will be reconsidered upon receipt of proper instructions by the learned counsel for the respondents. Okay,
Grateful.
we have keyed this one. 5th August.
Grateful.
July.
We can have it. We can have it on 29th of July.
But can it be in the first week or not? Actually, I'm in a parted, my lord, last week.
No,
or so.
madam has some difficulty and says
My
also.
lord, can I just to put a quietus, my lord? It'll be rest to.
No, not required.
This judgment is not considered stayed again. This is also in Supreme Court.
No, we have not taken note of
Please.
that judgment now.
Please.
We'll consider.
Lord,
On the
let
ninth.
it be-
Let it be on 5th July.
Yes, I'm so grateful.
You can take this back and place it on the next date.
Yes, ma'am. 5th of August, ma'am.
5th of August, correct. Wednesday.
I'm grateful.
Item 4.
Yeah, please look at BTC fishery, my lord. 16 and 17, 1624 given settlement, 20 page 17, my lord. This fresh settlement is given, my lord, without due procedure, my lord, no tender, nothing, my lord. That too when the code of conduct was going on. So aggrieved person has filed this case because if it is the 16, kindly see, my lord, it is 24 to 27. But before that, my lord, and secretly on behind the back, another settlement is given, and they come to know, no notice in paper, nothing. Impugned is page 17. And my lord, 27 is code of conduct also going on. They are hurriedly doing all these things.
See, this Santos is not before this court.
My lord.
This Santos Kumar Brahma is not before
Yes,
this
no,
court.
but we are not against this. We say that if you have given settlement, it should be a fair manner, my lord. It should be a paper publication.
So why have you given this history that you had a mutual consent
My lord.
that Santos
My
will
lord,
bid
because, I have,
and you will not bid?
yes,
You are
have,
forming a cartel.
my lord, yes, ma'am. It's an interested person. That is why I mentioned here. He is on the.
You have formed a cartel on the
Yes.
last occasion.
Yes, ma'am.
Yes, madam, how have you given the fishery?
Lordship, I
Without
have
a-
instruction, my lord.
But this is when was it done?
Already it has been settled with the respondent number 7 on 27 March 2026.
My lord, actually 15.3 is code of conduct is going on.
You-
but I
Why,
have-
why are you so late, Mr. Barua? I heard Sri M.J. Barua, learned counsel for the petitioner, full stop para. As per the facts projected, the petitioner is interested in fishing business,
Ma'am.
full stop. So far as the present fishery in question, namely the 1/70 Saraswar Beel fisheries under the BTC is concerned, comma, the grievance of the petitioner is the mode of the present selection which has been done without any tender process. Full stop. The petitioner has accordingly put to challenge a settlement order dated 27/3/2026 made with the respondent number 7. Correct?
My lord, yes.
Let notice be issued, returnable on 31st of July. Miss so-and-so, learned standing counsel BTC for 1, 2,
1, 2, 3,
3,
6.
3, 5, and 6. Embora,
B. Boranga.
Bibora. 4 and 4, you does State Council, extra copies. 7 by speed post with AD. Steps within 2 working days.
Obliged, ma'am.
You take steps early because
Ah.
other vacations it may not go.
Oh, please, Lord. Lordship, I have an account in my ICICI Bank Ulubari branch. But my account has been freezed via an email. Email is at page 15 notebook.
When was the freezing action done?
It was done in 14/5.
Huh?
14/5.
14/5.
Yes.
Yes, Mr. Sharma. How much, what do you do, Mr. Goi?
Lordship, they are saying that 12,000 rupees is in lien.
No, that is okay. What do you do?
I am an advocate.
Advocate.
Advocate by profession. The legal fees are deposited in my account.
Okay.
After that, they have freezed it.
Now, what was the amount involved which they claim to be fraudulent transaction?
12,000.
And the entire amount has been frozen.
A balance of 1,17,000.
May dispose of the matter because there is.
You have, Mr. Gogoi, you have
Yes.
earlier orders. That I think meat cutting,
Nepali cutting.
yes, that will cover. If make the corrections, we'll dispose of, okay? How much? 12,000 is the amount.
Amount they said is
Uh,
12,000 is the dispute.
We'll have it 25,000 on lane.
Yes.
Okay, the more than double.
Yes.
And rest operate. This lane will be for 6
Yes,
months.
yes.
Thereafter, this lane will also go.
Yes, sir.
Please make the corrections. দুইটা নাম লেখা, M. Gogoi and M. Sharma.
I will hand it over.
Considering the subject matter involved and as agreed to by the learned counsel for the parties, this requisition is taken up for disposal in the motion stage. Full stop. It is also in the learned counsel has also submitted that similar matters have been considered and disposed of. All right. 25,000 divided. 25,000. Lane after 6 months. Item number?
6, my lord.
Yes, Mr. Chaudhary.
My lord, in this case, my lord, petitioner was issued supply order, my lord, in connection with some MGNREGA scheme, my lord, and he supplied the materials, my lord.
You supplied.
Yes, my lord.
Thereafter,
Thereafter, my lord, due to some technical reason, my lord, the scheme was suspended, my lord. And thereafter, on the direction of, on instruction of additional deputy commissioner, my lord, scheme was verified, my lord. And kindly see, my lord, your lordship will find page 39, my lord.
so your ultimate prayer is for release of bills.
Bills, my lord, and my lord, because of a non-resumption of the scheme, my lord, the bills are not being paid, my lord.
So where is the admission?
Admission, my lord, there is in every bill, my lord, there is a my lord, your one of the copy, my lord. There is no dispute regarding the supply of material, my lord. My lord, only problem is.
We are not too much concerned with the dispute with the nature of supply. We are concerned with an acknowledgement of the liability.
Yes, my lord.
By the chief engineer or head of the department.
This is an MGNREGA block development officer, my lord.
Yes.
He acknowledged the bill, my lord.
Where is the acknowledgement of the liability? Acknowledging bill, what is the meaning of acknowledging the bill?
Yes.
Acknowledging the bill means he has received the bill.
No,
But there has to be an acknowledgement of the liability. Yes, I have to give.
kindly for a moment,
Page-
page 29A, my lord. One of the bill, my lord.
29
29A, my lord.
A.
29A.
Yes.
Certified that the material purchased found at work site in full quantity and good condition as
Yes.
per specification, so and so, namely construction name of the scheme, my lord.
So where is the liability of the amount to be given to you?
No.
This is receipt of the articles.
Yes, my lord. Receipt of the articles, my lord. They received the materials in a good condition.
That is not one of the conditions, Mr. Chaudhary. Condition is there has to be a liability for a writ court. You can have a very good case in the civil court. Writ court, there has to be a admission of the liability in writing by the head of the department. That is what we require.
Then, my lord, let them say if they.
Why
deny
should
my-
we burden them?
No, my lord.
To entertain a writ petition, that is the language employed by the Honorable full bench. To entertain a writ petition, not to adjudicate,
My lord,
only to entertain.
The problem is that, my lord, since the scheme has been suspended, my lord, the authority.
You approach the civil court. You approach the civil court. We cannot enter into this kind of questions.
Kindly, last annexure, my lord.
Page
Page, my lord.
42.
42, my lord.
42.
42, my lord.
What is there?
With reference to, I would like to inform you that letter has been received from CEO Hailakami regarding proposal for resumption of 7 suspended works for the year 2023-24 under Algapur Development Plan.
That is
Work-
for resumption of the work.
Yes, my lord. if the works is resumed, my lord, then my lord, this problem may not have come, my lord, if the work is resumed, my lord. That
But
will be
your, what is your prayer?
prayer,
Mr.
my lord,
Chaudhary?
for resumption of work, my lord.
Prayer for resumption of work.
If the work is resumed, my lord,
Let us see, what is your prayer?
First part resumption, second
Okay.
part release.
Heard Sri AHMR Chaudhary, learned counsel for the petitioner. Full stop. As per the facts projected, the petitioner was entrusted with work orders for in the year 2024 for supply of materials under 7 numbers of schemes under the MG Enrega 2023-24. Full stop. The grievance of the petitioner is with regard to the suspension of the schemes and consequent non-payment of the bills. Full stop. Para. Let notice be issued. No, Taragot Sri S. Datta, the learned standing council PNRD has however submitted that so far as the second prayer is concerned regarding a direction for release of the contractual bills, there is no document which our document to show that the head of the department had acknowledged the liability in writing. Full stop. Para. Be that as it may, since there is also a prayer for resuming the scheme, let notice be issued, returnable on 3rd of August 2026. Sri Datta, the Learned Standing Council, PNRD for 1, 2,
1, 2, 4, and 5.
1, 2, 4, and 5, and Sri R. Talukdar, State Council for Sri Extra Office. Deeply.
May it please your lordship. Lordship, the resolution plan was accepted on 2024, your lordship.
Yes, Mr. Smith. Yes.
And your lordship, just
No.
if your lordship may turn to page 181 for a moment, your lordship. 181.
What were the facts, Mr. Sharma?
Your lordship, the insolvency proceeding was proceeded against the erstwhile Ayushindra Hospital, Gauhati Private Limited. Then one Perles Hospital, Hospitex Research Center was a successful resolution applicant. His resolution plan was accepted by the NCLT on 2012-2024. Upon becoming the successful resolution applicant, he became the management and new management, the owner of the hospital.
You are that.
Yes, and the name of Ayushindra Hospital has been now converted to Peerless Hospital. Now, thing is that ESI has participated in the resolution process, submitted claim, and the claim was accepted and paid. That your lordship will find at page 181.
Okay.
181 is it was paid by the erstwhile resolution professional. The entire amount was paid. And that
Interim resolution process.
yes,
Okay.
and that amount was paid and pertains to period prior to 2012-2024. Now, your lordship sees the impugn order at page 192. They have now given a demand notice.
Yes, Mr. Smith.
Claiming
One notice was also sent, my lord.
But you had placed your claim before the interim resolution professional. It was settled.
yes,
I have to receive the instruction, but as part of law, the act, under section 87,
No, you have all the rights. Your rights are sacrosanct. But rights, you had the opportunity of placing your rights, got it adjudicated, paid. It cannot come in matters of kist installments.
I'll receive my instruction, my lord. The office was closed.
Now what will happen to them?
I'll receive my instruction. That in the meantime, my
Now
lord,
their rights have also accrued.
my lord. That is time I'll receive my instruction, my lord.
now there is a
Right,
threat
right.
of even appointing receiver, attachment,
Now,
seal, everything.
Under same act, Insolvency Act.
But
That may be
and this is a hospital that is operating
in my non-humble submission.
Where is your hospital?
in Gauhati.
Oh, Gorchuk.
Yes.
Okay.
Lordship may just.
You're now called Peerless Hospital?
Yes, Peerless Hospital.
Okay.
Peerless Hospital, Guwahati Private Limited.
Okay.
The notice is to them, Your Lordship.
Okay.
There's one judgment that I'm relying, Your Lordship. may just-
No, not required at
Ah.
this stage. Third, Sri R. Sharma, learned counsel for the petitioner. First of the petitioner has put to challenge the action of the ESIC seeking to recover an amount of rupees 30,27,049 from the
Period from 10/2023 to September 2024. Page
From the-
193.
from the petitioner. Full stop. Briefly stated, comma. One Ayur Sundra Hospitals, within bracket Guwahati Private Limited. Briefly stated, a proceeding under the Insolvency and Bankruptcy Code 2016 was initiated qua an entity called Ayur Sundra Hospitals, within bracket Guwahati Private Limited, in which an interim resolution professional was appointed and the ESIC had submitted its claim. Full stop. The claim was scrutinized and stood quantified as at rupees 45,98,802, which was paid. Full stop. The resolution plan was submitted by the present petitioner, which was approved by the NCLT Guwahati under section 31
Yes.
of the
Lordship,
code.
It was submitted by Peerless Hospital, Hospitex and Research. He was the applicant.
By Peerless Hospitex
Tex Hospital
Hospital and Research Center Limited.
He was
uh,
a subsequent successful applicant.
Under section 31 of the code, and the same was approved, and the approved at an admitted claim of rupees 45,98,802. Correct?
Yes.
And the same full stop. However, long thereafter, the present demand has been made by the ESIC, in spite of the fact that the claim of the ESIC was taken into consideration, adjudicated, and paid. Full stop, Kara. Let notice be issued, returnable on 3rd of August 2026. Sri M. Smith, Learned Standing Counsel,
125.
ESIC, accepts notice on behalf of
125. Madam.
all the respondents.
No, 125. Madam.
1 to 5.
There's one before.
Who was 5? 6 is the IRP.
Yes.
Resolution provision. Okay. 1 to 5. Extra copies. Let steps be taken for service of notice upon the respondent 6 by speed post to TD. Steps within 2 working days. Para 3. Sharma, the learned counsel for the petitioner, prays for an interim order. Para, considering the facts and circumstances, comma, this court is of the opinion that a case for passing an interim order is made out, full stop, accordingly, comma, further proceedings pursuant to the notice dated 8/6/2026 shall remain suspended, full stop. The interim order having been passed at the motion stage, comma, the same would be reconsidered upon instructions being received by the learned standing counsel on the returnable date.
Obliged. Lordship, only thing the resolution plan was approved by NCLT on 20/12/2024. With that date.
NCLT on approved on 2012.
2024.
Okay.
Because the claim is now prior to that date. Much obliged, Your Lordship.
Item 10, what? Yes, this is also, I think, ESIC. Yes, what is it, Mr. D?
Uh, uh, Actually, the fact is that on 2025, 28/4/2025, a prohibitory order was passed by recovery officer ESIC. and my State Bank account was blocked. In few days,
What was blocked?
my State Bank
SB account.
SBI
SBI account blocked.
was blocked. Actually freezed. The
Frozen,
technical term is
okay.
freezed. And after two or 3 days, my HDFC bank bank account was also freezed.
Hmm.
But initially I could not recollect whether I have done any sort of registration with ESIC or not, because I'm in a small town and it is very new for me.
What
But
business do you do?
I have a pharmacy, but in 2018, I did a contract of municipality
Hmm.
for construction. For that reason, chartered accountant has done some registration also. At that time, labor registration was also there. ESS was done also. Subsequently, I got to know that is I have did it.
Hmm.
But during Corona, I have stopped this business.
Hmm.
Now, the matter is that when prohibited order was passed, and I immediately contact with ESIC department. Then I got to know that an ex parte order under section 45A has been passed against me on 12/11/2024. It is in page number 35. So in that particular order, it has been said that they have several times communicated with me. I never come up. That's why they have charged a certain amount, around 3,40,000 or something like that.
Hmm.
This is the case actually. I made a representation that I have never been
Informed.
communicated, informed, and in last 7 years they never visited my place, and I wanted them to be heard. My representative was very specific. I want that breakups of that particular amount, what they are charging, how they calculated it. Number two, I want to be heard. They said at that particular stage, there is no provision. That's why I approached insurance court, and insurance court to file an appeal. There is a mandatory provision under section 75 that 50% deposit should be here.
Correct.
And I have done a representation, miscase number 13, page number 38, where I have said I was not at all communicated. That's why that particular the mandatory provision should be waived in accordance with the law. There is a provision also. And on order dated 28/8/2025, insurance court has passed an order favoring me. This particular order is in 51, page number 51. After that particular order, ESIC court has filed an objection. After that objection, a hearing took place. We had objected because we are saying that number one, the ESIC insurance court cannot modify its own order. They should go to the upper court or any other forum, and they can maybe in certain cases then can modify, but in that case new circumstances or facts must be arised. So on order dated 28/1/2026, completely opposite order has been passed, and 50% deposit, honorable court has ordered us to deposit 50% amount. Now, honorable court did not consider that already 44,000 they have taken from my account. So if 50% more I could do, it will actually will be an abuse of law. Number one. Number two, your lordship may go to page number 59. It is their objection. Actually, their objection petition is actually justifying our claim.
Now, what is your grievance now? What is your grievance?
My grievance is that order dated 28/1/2026 should be stayed, and
Where is that order?
Order
Page?
76. Before that, order dated 28/8/2025 should be read. It is in
No,
page
that is okay.
Okay.
Now, what has
Okay.
this order said?
page number 76.
Mr. Smith, he says, we are not on the other aspects.
My lord.
He says that an amount of around 44,000 has already been recovered. Will that amount to 50% of the, that will not amount to 50%.
That instruction I do not 45. Here, the case of the petitioner, he is challenging the order of the EI court, which is equivalent to a civil court as per the act. If your lordship may peruse the section 78 of the ASI Act,
78.
78.
Yes. Hmm. Yes.
Sorry, lordship. Look, some the powers of the employees insurance court,
Hmm.
The employees insurance court shall have all the powers of a civil court
Hmm.
for the purpose of summoning and enforcing the attendance of witnesses, compelling the discovery and production of documents and material objects,
Hmm.
administering oath and recording evidence, and such court shall be deemed to be a civil court within the meaning of section 195, chapter 7 of the Criminal Procedure Code.
Hmm.
The employees insurance court should follow such procedure as may be prescribed by rules made by the
Hmm.
state government. And the surplus 4, that's important. An order of the employees insurance court shall be enforceable as if it is a decree passed by a suit in a civil court.
Correct.
Now, he has approached this court by way of 226, my lord.
No, this is not a final order.
And this is not a
This is only with regard to deposit.
deposit, man. That is deposit during the 50%, man. The employees insurance court, man, what if it's agreed, my lord, he could have approached this court by way of filing a civil division petition, my lord. That is my submission. And
No,
my
it's
lord,
not a
if-
civil, don't mistake, Mr.
Madam.
Smith. Don't mistake in understanding of law.
my lord,
This provision which you have referred or relied will not make that court a civil court. It is only giving certain powers
my lord,
under the CPC, like summoning of witnesses.
my lord,
Even a consumer, if you read the Consumer Act
my lord,
or many other act
my
or
lord,
Arbitration Act,
my lord,
the same powers are granted to only to ensure
my lord,
that the proceeding can be conducted smoothly.
my lord,
Certain powers under CPC are granted for summoning a witness, recording of evidence.
my lord.
This will not convert it into a civil court. That is a wrong submission.
Well, then
You
I-
understand properly.
but
But
if-
we are on the other aspect.
Well-
Do you have the power of reviewing your own decision?
well, that part of the insurance court with the power reviewing own decision, that has to be considered. Man.
No, whether that is there, we do not know. We are asking you. Does the Insurance Act of 1948, Employee State Insurance Act of 1948
That
gives
is-
the power of review?
No,
First, that would be the foremost condition.
my lord,
He has approached this court late.
my
The
lord,
moment it was proceeded, second time he should have come.
my lord,
He has waited till the orders were passed.
my lord. But that is there, man. But if I may. then
You examine the matter. Presently put this on hold. Okay.
my lord,
You examine the matter. Returnable date will come with instructions, both on the aspect of review and other. Third, are they learned counsel for the petitioner who has put to challenge an order dated 28/1/2026 passed by the Employees Insurance Court of Assam, Kamrup, in Miss Case number 13 of 2025, arising out of ESI case number 5 of 2025. Full stop. By the aforesaid order, comma, the earlier order dated 28/8/2025 was modified, and the present petitioner is required to deposit 50% of the amount involved in the lease alias bracket. It is contended that by the earlier order dated 28/8/2025, comma, the page 51. Comma, the requirement of deposit of 50% was waived. Full stop. Para. The learned counsel for the petitioner has made several contentions to justify the requirement of such waiver and one of the prime contention is that no prior opportunity was granted to the petitioner regarding the demand in question. Let notice be issued returnable on on which date on the 5th of August, 5th of August, Sri M. Smith, Standing Counsel ESIC, accepts notice on behalf of all the respondents. Let extra copies be served upon him. There. Sri D. The learned counsel prays for an interim order. Put the para. After considering the facts and circumstances, the operation of the impugned order dated 28/1/2026 is kept under suspension. Full stop. The interim order would, however, be reconsidered on the returnable date.
Obliged.
What are the consequences of this? You kindly apprise. Because this is not a.
Amount is recovered, that
No, we are only on the aspect of 50%. The main issue has not been adjudicated or answered. We don't want the main issue to be kept pending. We'll decide on this whether requirement of 50 is there or not, then we'll allow you to proceed. Otherwise, we cannot hold back. Even the earlier order, which he says it was in favor of him, has not obliterated the demand as such. It is only obliterated or waived the requirement of 50% pre-deposit. Okay.
That's obliged.
Here in this case, my lord, the petitioner has been marked as the voter in the.
Both these cases, my lord, 11 and 15. I need some time to get an instruction, my lord.
We have been deciding matters.
Some-
Instruction from the Superior Police Border that there is an empty case against him.
There is.
That is.
Now he is saying that when he inquired into.
There was no.
He is not finding the record. So it is only.
So let me get the instruction.
Okay, get the instructions. Okay.
What?
Third, 3
11 and
MH. These are all connected.
11 and 15.
11 and 15. my lord.
11, 15.
11 is husband, 15 is wife.
Separate. Third, 3 MH Talukdar, learned counsel for the petitioner, who is aggrieved by marking of D against his name in the voters list of 2017
Yes, my lord.
of village
Hormuz.
Harmuza
Yes, my lord.
in the district of Goalpara.
Yes.
LSC, we need the LSC.
$39.
Pertaining to 39 Jolish or LSC in the village of Kharmuza in the district of Goalpara. It is contended that in spite of efforts made, no FT case could be detected. That
My lord, kindly come to page number.
is his
11.
contention.
Yes, page number 11.
He has given.
Page number 11.
Okay. It is contended that though there is a reference to an FT case number, comma, in spite of a due diligence exercise, comma, no such case could be found
Yes, my lord.
in the foreigners tribunal. Para. At this stage, comma, both Sri, you will take or you will take. Both don't say. Sri J. Payang, learned standing counsel, prays for some time to obtain necessary instructions. We can issue notice.
Yes.
Let notice be issued. Returnable on 5th of August.
Yes.
5th of August 2026. Union of India, anyone? LDB for 1, Union of India. Then Sri J. Payang for 2,
2 and my lord, 7.
2 and 7, J. Payang. Then AI Ali, standing counsel
3, 4, 6, and 8.
3, 4, 6 and 8. And district commissioner are 5. What about extra copies? Six.
In item number 15 also.
Same. I think he's too hard. Constituency in the same.
Yes, my
You
lord.
reside together,
Yes, my lord. Husband and
husband
wife.
and wife,
Yes, my lord.
residing together.
Yes, my lord. My lord, they are regular voters since 1985, but in the voter list of 2017, they have been marked. Obviously.
Item number?
May I please, Your Lordship. Lordship, blacklisting debarment matter, Lordship. Your Lordship may find the tender at page 31. The debarment clause is at page 51, Lordship. Page 51. Lordship got it? H, debarment.
Yes.
Product debarment. In case of non-supply or incomplete supply by the approved
So
manufacturer.
what are your grounds, Mr. Sahiwala?
Lordship, the cause of action involved in this matter has already been adjudicated by a coordinate bench of this court, Lordship.
Lordship, that matter, Lordship, I'm not looking into, Lordship. Mr. DP Bora is appearing in that matter. So, Lordship, let notice be issued. I'll get the instruction.
Lordship, I'm praying for a stay of the debarment order, Lordship.
Show it to your colleague also. Same debarment order or the issue.
Same tender, Lordship. Same tender, same type of debarment order. The tender is same. Lordship, may see
What are the grounds of around the petition?
Lordship, the firm debarment can only be done after the responding authorities cancels the rate contract entered into with the petitioner for the products for which the petitioner is empaneled. Thereafter, the product has to be debarred and subsequently the firm debarment can be done, Lordship. Lordship may see para 12 for the para 11 and 12 of the judgment.
Of the judgment.
This is a different firm, Lordship.
Lordship, same tender, different petitioner, but the same cause of action. Lordship. Para 11. From a perusal of the above.
Mr. Sahiwala will consider a prayer on the returnable date. We'll give a short returnable date.
Yes.
You go through it.
Yes, Lordship.
Because he wants to participate in new
Lordship,
project.
due to this debarment,
We cannot
time
prejudice
here
him.
we are
Okay.
not able to.
Lordship.
Heard 3M Sahiwala Learned Counsel for the petitioner who is aggrieved by a notice of debarment dated 13/11/2025
Lordship.
issued by the Health Department.
AMSCL, Lordship. AMSCL. Assam Medical Services Corporation Limited.
Assam Medical Services Corporation Limited. Full stop. Amongst others, it is contended that pertaining to the same tender, there was a similar action taken against another entity
Lordship.
on identical grounds,
Same. Lordship.
which has been interfered with by this court, wide an order dated
11 December 2025.
11 December 2025 passed in WPC 6735 of 2025 bracket likhiba Nestor Pharmaceuticals here prosailoba. Okay. Let Sri Upamanyu, the learned standing counsel, has however submitted that he would require some time to go through the said judgment. This court is of the opinion that the matter would require urgent consideration. Full stop. Let notice be issued returnable on, we'll have it immediately, okay?
Yes,
On 28th of July, 2026. Sri Upamanyu, the learned standing counsel, accepts notice on behalf of
All the
all the respondents. Let extra copies be served upon him during the course of the day. On the next date fixed, the interim prayer would be considered.
Highly
You can take a copy of that, Mr. Upamanyu, and give copies to him today itself. 13 to who na? Or 13 Insurance Regulatory and Development Authority of the who's there? None appears for the petitioner on call. In the interest of justice, matter is adjourned to be listed for motion immediately after the vacation. Okay. Yes, Mr. Ali.
May I please the Lord. Yeah, my lord, the petitioner, my lord, is a sitting lessee of a Parghat, my lord. And his term will expire on 30th of June, my lord. And in the last year, my lord, as per new policy, my lord, the settlement holder, my lord, should deposit entire kist money at the time of taken over the position. Petitioner deposited entire kist money, my lord. And this year, my lord, as per Panchayat Act, my lord, NIT ought to have been issued, my lord, prior to 45 days. In this case, my lord, no NIT has been issued. Therefore, my lord, petitioner approached the authority, my lord, to give him settlement at the rate of 10% because this is their policy, my lord. No action has been taken, no settlement, my lord,
My lord,
and third party is going to be
He
settled.
wants, Mr. Ali wants a walkover.
There are three prayers in the petition, my lord. First prayer, my lord, I have instruction that because of some government instruction, they are awaiting in the whole state. Not a single NIT was issued, my lord. The for second, my lord, this is premature prayer, my lord, because till that no, the third party claim is not there. And paragraph 3, my lord, his extension that is not permissible under this act. So repetition is liable.
But he has one thing in advantage. He moves the worst case on the last date. So that it is not dismissed in limine.
Third party.
He might get advantage of that strategical move. But you don't have anything, Mr. Ali.
As per Panchayat Act, my lord, NIT should be there.
That how will that give you any right?
And third party, my lord,
You have
direct
not come up in public interest.
lordship, direct settlement, my lord.
You
to
are a
third
settlement
party.
holder, you are an interested party. You want your extension to be made
I'm not, my lord, directly, I'm not paying for the
indirectly.
extension. my lord.
Indirectly.
Because till final, my lord, NIT process is completed, my lord.
That
Because
cannot be, my lord. There are numbers of
because-
judgments.
Okay, let us not dismiss this.
let them bring instruction, my lord,
May not be required.
regarding settlement, my
On
lord.
the reopening, we'll dismiss it. Heard Sri R. Ali Learned Counsel for the petitioner. Full stop. As per the facts projected, the petitioner was settled with the Kundana Bari within bracket Pathar bracket close Ghat for the period 25-26, and the said settlement would expire on 30-6-2026. Full stop. It is contended that for a new process of settlement, the NIT has to be issued at least 45 days. Mr. Ali, at least 45 days prior to expiry of the earlier settlement, which has not been done. Full stop. The petitioner is willing to run the Parghat at an enhanced rate of 10%. Full stop. Para. On the other hand, Sri S. Datta, Learned Standing Council PNRD has submitted that due to certain valid reasons, NITs for Parghats across the state are put to an hold, which, however, will not give any right of extension to the petitioner. Let notice be issued, returnable on the. Will not get anything otherwise also. 30th is going to be over. On the 27th of July, 2026, Sri Datta, the Learned Standing Council, all the respondents. No, secretary also.
Yes, ma'am.
He's a government.
Extra copies.
All right.
I love.
Lordship, yes, Lordship, here in this case, Lordship, I have to file an affidavit, Lordship. Can you fix the matter after vacation, Lordship? In the meantime, I will file that.
What is the matter, madam?
Non-payment of the dues. There's another connected matter.
Yes, Lordship.
Non-payment of 2 crores 15 lakhs for the supplies made.
You had made certain supplies to the
Yes.
department. What
And
is the other matter?
Other matter is 4983 of 2025.
Okay. Heard Miss M. Hazarika, Senior Counsel, assisted by Ms. So for the petitioner. Para. Also heard Sri Goswami,
Standing Council, Animal Husbandry.
J.K. Goswami, Standing Council, Animal Husbandry and Veterinary Department. Full stop. The Standing Council has, however, submitted that some more time be granted to enable him to obtain the instructions and file the affidavit. Para. The Learned Senior Counsel for the petitioner has informed this court that a similar matter being WPC
Connected matter.
Connected matter.
Connect-
That connected matter WPC 4983 of 25 is pending. Better? In view of the above, matter is adjourned to be listed on when?
Lordship,
Tell
can it be
us.
on,
5th of August,
Yes, Lordship.
Lordship, 5th of, Lordship, can it be on,
3rd of August,
28 July, Lordship?
28th,
Lordship.
Affidavit file করবা
20th Tuesday. What happened on
Fifth
Tuesday?
করা। Affidavit file করবা
Huh?
Lordship,
20 or 28?
2028.
20 or 28? Which one?
20, Lordship.
20th,
28.
madam, 20th.
Yeah, let him file his affidavit.
Okay, 20th of July, 2026, along with, at least along with WPC. 4983 of 2025.
Lordship.
Oh, okay, wish you all a very happy
Thank-
vacation.
Thank you, sir.
Thank
Same to you.
you.
Same to you.